My wife has written out that I have to report to her if I leave town. I don't want to report to her every minute of every day what I'm doing.
Does she extend you the same courtesy? When the child is with you, then you have the responsibility of making those day-to-day decisions.
We've agreed a price on the house, a hell of a lot less than I was hoping for. I can't afford anything, big enough for 2 children and myself on my wage.
That changes everything and makes me want to scream and go, absolutely, Josie, make an appointment with me.
We're at conditional order. What do I do if he's delaying the financial agreement?
You're kind of stuck, really. You're going to have to make a court application. Hi everyone and welcome back to the Legal Queen live show. My name is Tracey Maloney, aka the Legal Queen on social media. I am a practicing family law solicitor and have been now for over 20 years. During that time, I've helped thousands of people with their family law questions and queries to include divorce, children matters, and of course, finance. So if you have an issue or a question or even a problem that you think I could help you with, please join me on the Legal Queen Discord. Come into the audience, pop up your hand. I'll invite you onto the stage to ask me your question. Now on with the show.
Hello, can you hear me?
I can, yes. How can I help?
Excellent. I'm currently going through mediation. We've agreed 50-50 custody of our daughter who has a medical condition.
Yeah.
Now, my wife has written out a big list of clauses so that when we're apart that I have to report to her if I leave town. Obviously, holidays isn't a problem, but there's these big clauses of things I can and can't do with my daughter. And she's sort of put that under the guise of safeguarding, and she needs to be aware of where she is at all times. I was just wondering what the chances of actually getting that, because she wants it to be written up as a court document. So, and if I breach these conditions, then it's the threat of going back to court to change custody and things like that. Is that normal for people to put these sort of things in, these clauses, or is that like a bit far-fetched?
Okay, so a couple of things there that I would say. I don't know what the clauses are, so I can't comment on the normality of them. But yes, I mean, lots of weird and wonderful things go into orders. They're very bespoke to that family. But the important thing here is that where we have 2 parents that agree on where the children live and all the bits and bobs around the children's daily lives and responsibilities, etc., we generally don't send that into court. The court in that instance will apply what's called the no order principle, whereby they won't make an order if parents are in agreement. Totally different to a financial order, where we have an agreement with finances, we want the order, and the court will make it. But with children, that's difficult. So my question would be back to you. If you are in agreement with what mum is requesting from you, then there is no need for the order. If you are not, if you're not in agreement, then you're not going to sign it. So what mum then has to do is make a C-100 application. And then the court decide if mum's clauses are appropriate.
Right. Okay. So things like I have to ring up and let her know if I'm leaving our town to go on a day trip or visit family or whatever. Are those things like upholdable? Or no, that's the right word.
So,
but if I don't want to report to her every minute of every day what I'm doing, basically.
And does she need you to report in when you've got the children, or when you are just going about your daily business?
No, just when I've got the child. So we've agreed like a 4-3 split.
Yeah.
And
then the answer to that question is no. You don't have to report your every move. Does she extend you the same courtesy? Does she tell you what she's doing?
No, I don't want to. Like, basically, once we're divorced and stuff, when my daughter's with her, then she's free to do as she pleases.
Yeah.
But
And
unfortunately, it's not reciprocated.
yeah, and that's my point. You have parental responsibility. So when the child is with you, then you have the responsibility of making those day-to-day decisions as to where you go, who the child sees, what they eat, what time they go to bed, if they brush their teeth, or if they drink fizzy pop. Do you know what I mean? It's entirely up to you. So no is the answer to that question. I see it a lot where one parent can be fairly controlling of the other. And almost uses the children to exercise a certain amount of power. It tells me that maybe there's no closure there, or there are feelings of resentment or what have you. And it's the wrong way to channel it through the children. It really is, because it impacts on them. They just want to be with you and spend time with you, not have you on the phone to mum saying, right, we're just going here, we're just going there. It's no, the court certainly wouldn't uphold that without good reason. Absolutely not.
Okay, brilliant. Thank you very much.
Pleasure. Bye now.
So I unfortunately had a not a very nice end to a relationship that I chose to get out of. So almost a 15-year marriage.
Yes.
And he was on he was on bail for quite a few months, so I had no contact. And when he had contact, he's sort of all on his terms, and obviously I've agreed for that to happen, but the kids seem comfortable enough. The only problem is since that contact, he's kind of being more intrusive and coming back into my life and the children's lives, to the point where I just feel like I just can't stay in the family home, even though at the time I made the decision that obviously I can't afford anything, big enough for 2 children and myself on my wage.
Yeah.
If we sold. So I wanted to get an occupational order.
Yes.
The problem is, we went through mediation. He then refused mediation, so I've paid for all that myself. I paid for the divorce that's still going through, and it was it's being pronounced at the end of this month, so I think tomorrow. But I haven't got any other. I haven't got a solicitor at the moment because they were disinstructed. I didn't have the money at the time, but we've now agreed a sale, and I'm reluctant to go through with it because I feel like I'm putting myself in a bit of a situation. And I don't really know whether I need legal advice and to sit down with someone again, because really we've agreed a price on the house for the buyers that are a hell of a lot less than I was hoping for.
Yeah.
And he wants to go for 50-50, but obviously I have the children most of the time. He only sees them every other week. On weekends, and he pushes for 50-50 on holidays, but doesn't have them 50-50.
I think
for example,
you
the 6 weeks holidays, only having them 1 week.
Yeah.
So I just don't know what to do, really.
I'm a big believer, even though I'm a lawyer, qualified lawyer, I'm a big believer in go with your gut. And I think, Josie, your gut is definitely telling you need to get advice. I mean, obviously, I can't give you advice on this public forum, but 2 things that you've commented upon there are both red flags to me that makes me want to scream and go, absolutely, Josie, make an appointment with me. The first one is that it definitely wouldn't be a 50-50 because the children are with you. And I say that with confidence, even though I don't know ages, what your earning capacity are, etc. And the second thing is that you say that the offer you have had made on the property is a lot lower than you had anticipated. That changes everything. We've got to think less about percentages and more about needs. Percentages work where we've got plenty of equity. We've got maybe 500,000, 600,000, 700,000 once the house is sold. We've got plenty of equity there to cater for everybody's housing needs. And then we can start to think more about percentages. But sometimes one of the parties will get 90%, not because they deserve 90%, but because actually the offer made on the property means that they're going to have the bigger piece of it because they're housing the children. So I think the fact that the property has dropped in value, or the offer that you've had is considerably lower, that also tells me that you need some advice, because that's going to change the whole landscape of what the settlement's going to be. You mentioned, has he actually left? Has he moved out?
He was removed.
Okay. And how long
and
ago
obviously didn't come back.
And how long ago was that?
That was October last year.
So we're confident that he's not on a park bench and that he's got somewhere else to live.
Yes.
Because the
Yeah.
reason I kind of sway people away from the occupation orders is A, they're expensive, B, they are really difficult to win, and C, they take such a long time to get before the court. But know that, and you may have done this already, you can change the locks now to actually stop him from coming in. So, you know, if
they changed the locks, so that has been done. The police did that.
Great.
Yeah.
So then if he's still coming round to the property, and because I sensed from when you first started to talk to me that you really do feel so despondent now that you've almost lost control of it all. But and I'm kind of keen.
He's been in control the whole marriage.
Yeah.
So I'm kind of I feel like every time I get into a conversation with him, it's his way.
Yeah, his
he
way or
always
no way.
twists and manipulates it all, and
absolutely. So again, there's only so much I can ask you on this public forum, but please reach out, drop me an email, and let's see if we can't just get even a short consultation booked, just so that it's really important that you know what you're legally entitled to, and then you can move forward with that knowledge. It'll also give you confidence. Okay.
Yeah.
Brill.
Thank you.
All right. Pleasure. Thanks, Josie. Bye-bye.
I have a question. So, our divorce application has been ongoing for 3 years.
Yes.
We're at conditional order, and we're just doing the financial things. I've submitted to my solicitor my bank statements 3 or 4 times now because he's delaying it. What do I do if he's delaying the financial agreement? What can I do, essentially?
Yeah. So, sorry, did you say, Bex, that you were in court with this one?
No, it's not in court with the divorce.
So you're doing a
financial order at the moment.
But you're doing it voluntarily, is what I'm getting at.
Yeah.
Okay.
Yeah.
So
voluntary disclosure.
Where it's all voluntary, there's nothing you can do. If they don't want to do the Form E, if they don't want to provide their financial disclosure, that you're kind of stuck, really. So what I generally say to people in that instance is you're going to have to make a court application, because once you make the application for finances, the court's then going to order the other side to put forward their Form E and all their financial disclosure.
Right.
And if they don't do it for the judge, then at least the judge has the power to make an order in the absence of their evidence. Okay. So the important thing sometimes about making the court application is not necessarily because we want to go to court, but it's more that we are putting a finish line down then. You know what I mean? Because otherwise, voluntary, you've both got to be willing to do it. When it's voluntary, you've both got to be highly motivated.
Yeah, all it is a clean break. We're just doing the clean break order, but due to previous domestic abuse and things, it just hasn't, it's like he's just like, nah, I'm not doing it, even though he put the application in.
Oh, that's such a shame, especially when it's just a clean break that's needed. But look, the good thing is you're probably not going to have 3 hearings, because when we make a financial application, it generates 3 hearings. You're probably going to settle yours at number 2. So you're looking at anywhere between sort of 4 to 6 months. So I would be suggesting, give them one final chance, 14 days. And if you haven't heard anything, make the application.
Great stuff.
All right.
Thank you so much.
No problem. Thanks now.
Thank you.
Bye-bye.
So I've had my first financial review with my ex-partner.
Yes.
In a court. Basically, the long and the short of it is she's not negotiating.
Yeah.
And the judges all prepare to start negotiating, but she's just not having it at all.
Right.
I'm doing quite a lot more money than I'm receiving pension-wise and balance of the house that we've sold. But she wants to go for spousal maintenance as well.
Right.
But I'm not in that position where I can actually do that for her. So the judges advise we start at 50-50 and then we go on. But I'm a bit kind of stuck, really, because I'm offering a 60-40 now.
Yeah.
But what's the odds if we go all the way to can't.
The difficulty that I have is that this isn't that generalized question for signposting or guidance. You actually need advice, because what you're asking me is, should it be 50-50? Should I offer her more? Is that right? She's not agreeing. What can I do? This definitely needs an appointment with me, even if it's just a 30-minute appointment, so we can run through the logistics or run through the assets in the marriage. If the court is suggesting that you start at 50-50, that tells me that this is potentially a long relationship. But I've yet, yeah. So, and that's why the court's saying that's our starting point. I would say 9 out of 10 of every financial orders that I do, they will never end at 50-50. There is always a reason why one party is a little bit more in need of a little bit more than 50%. So if you want to drop me an email, let's start with an email first, and I can go from there. It might be that we can sort of circumnavigate the appointment if I just ask a couple of questions via email. But definitely, I don't want to ask you questions on this forum because there's hundreds of people listening.
No.
But yeah,
it didn't really help the judge. The judge wasn't prepared for our first financial meeting. He hadn't read the notes or anything, and it's quite unprofessional of him.
Sadly, that is sadly that is becoming more and more of a concern. I think it's because of the volume of applications, and I'm not making any excuses for the court. They list the cases, they should be ready to hear our applications, but unfortunately, a lot of times they're just not. They're not ready. I oftentimes am correcting the court, diplomatically, and saying, I think you might be referring to a different case. This isn't our case, blah, blah, blah. We don't even have children in this matter, for example. It's a sad fact. There are just thousands and thousands of applications being made at the moment.
Right. Fantastic. Thank you very much.
No
I'll drop you an email.
All right then. Thanks. Bye-bye.
Dad's not involved in the child's life. What happens then if mum dies? Does it automatically go to dad when dad is not suitable to look after the kid?
Well, no. So I get asked this question all the time. The other parent has parental responsibility, but there are safeguarding concerns, or there's issues, or whatever it might be. So if I die, will the child be automatically handed over to them? Absolutely not. I mean, the first thing, if we think about it in reality, if mum was to die, she's most likely got an immediate family who are now going to start to raise the child. Okay, we're then going to wait for dad to potentially step forward and say, I want the child. I now challenge the child living with the grandparents or the auntie or whoever it might be. And then he'd have to start a court application. By the same token, the mother's family might then say, well, actually, we're going to start a court application because the child is living with us. Dad doesn't contest that, and we need to get parental responsibility. I would always be suggesting that if a family is put in that position, that they reach out to social services and get social services support before they go to court. But no, I mean, social services aren't that carefree. They're simply not going to hand a child over to any other adult that has PR just because they have PR if we've got genuine safeguarding concerns.
Hi, just a quick question. So today was the deadline when I had to submit the statements, and the applicant had to submit the witness statements in regards to disputing a non-molestation order.
Yes.
I've met my deadline, but unfortunately, applicant haven't.
Yeah.
Now I've emailed to a court to find out why I haven't received such a witness statements from the applicant.
Yes.
And I have no answer. The applicant's solicitor is ignoring my emails, and I'm just trying to understand how I can get them and from who, as it's been ordered by the court. Thank you.
Well, you can't really. I mean, if they don't put a statement forward you're not going to be able to get hold
They
of.
did, but just they didn't to me. Sorry.
Oh, I see. Sorry. So they haven't served you with the statement. Well, they have to if they're court ordered to. And if they don't, you might want to write into the court and ask them to provide you with a copy of it, which is highly unethical. But of course, you don't want to be going to the hearing without having read that statement. So if I was in your shoes, I'd be sending the other side solicitors, or if they're not represented to them directly, a copy of the order with it highlighted to say you are to file and serve. File means you're sending it to the court, and serve means that you're sending it to your opponent. And maybe, if they see it in writing, then they might forward it to you. Ultimately, if you don't see it before the hearing, it may impair that hearing. That hearing may not be able to go ahead.
So far, what I've emailed to a court
Yeah.
to notify them that I haven't received the applicant's written statements
Yeah.
by the deadline imposed by the court.
Yeah.
And they replied to an email that regardless if I disputing or accepting the non-molestation, I still have to be served.
You still have to be what?
And
you still have
also
to
they
be
stated,
served,
the
yeah.
court stated, I still have to receive them.
Yeah.
And also the court mentioned that they said to me, you should ask them why they haven't done so. And on them questions to our applicant's solicitor, she's just ignoring.
Okay. Well, I'm not sure that you can do much more. I mean, we can't force somebody to do anything. All you're going to have to do is be patient, wait for the court hearing to come around. And when you go to court, you just let the court know, I haven't seen the statement, Judge. It might be that we need to adjourn the hearing because I have to see and read this statement and they didn't give it to me. Make sure that you bring a copy of all your emails with you, of you asking the other side for their statement. And that's it. I mean, maybe they're late in filing it. I don't know. But you can't do any more than that. There isn't any sort of magic answer I have for that one.
Hi, can you hear me?
Hello. Yes, I can.
Right. It's not really a question, it's a thank you, if
Oh,
that's okay.
absolutely.
You gave me advice not long ago about Section 91, and
Yes.
it's a case where there's been a long stream of lots of court applications, and
Yeah.
it's domestic abuse in
Yeah.
the history and things. And you gave me some advice, and I wanted to say that we've got the Section 91. We now have a good 4 or 5 years of not having to worry about being dragged back to court and go through it all over
Brilliant.
again. And I just wanted to thank you for your advice, because it's a huge weight off my shoulders.
That is such good news. And you know what? Thank you so much for coming back and telling me, because so many people don't. And I completely get it, because everyone's got busy lives. But the fact that you took the time out to come back and tell me about that, I'm made up. I'm so pleased. And as you say, at least you've got some breathing space now for another 4 or 5 years.
My son's on dialysis at the moment and heading towards a transplant. So having that taken away from us just for the next few years is going to be a huge help. So we're very, very grateful for your help. Thank you.
Absolute pleasure. Absolute pleasure. You take care. Thanks now.
You too. Bye.
Okay, bye-bye.
Hello.
Hello. How can I help?
It's just a quick one. It's about this parenting plan. I think I mentioned
Yes.
to you about it before. So we have this Kafka's monitoring order, which I seem like it's a mediation.
Yes.
So at the moment, Kafka's the worker, she says until she sees his the dad's home address and how he deals with the child at his house, she will not be able to approve overnight stays or just make the parenting plan. So now this occasion meant to be this Monday, but obviously dad didn't agree anything with her. So I guess I don't know what's going on in the background. So you always say that you can't force a parent. So is this mean in your reading I should just leave it? I shouldn't because I asked him if you're gonna reschedule the date. He can't answer the question.
Yeah.
It's just, it seems like he doesn't want to have that date.
Yeah, and
with the Kafka's worker.
Yeah, and I think that there comes a point, Nancy, where you just need to step back. It's really sad where one parent is just trying to organise or trying to, keep the routine going or whatever it is that the parent's doing. I know that's a little bit different in your case, but yeah, we have to kind of afford them the responsibility of doing this. And if he's not interested, he's not interested. That's really sad.
Yeah,
But
it's just sad because my child, just keeps saying his name and his,
yeah,
dad and stuff like that, and it's no good.
yeah,
I feel for every parent who is trying to, get the dad involved or the mom involved. It's not always the dads, but yeah, it's
yeah.
just really sad for the child.
It is sad. It
Yeah.
really is sad. But yeah, sorry, Ansi, I couldn't give you any better answer than that.
And my other question, sorry, which was
Yeah.
just the clause someone else was talking about.
Yeah.
If we go back to court, because I do think he just wants me to, go back to court, have some hassle and all these things.
Yeah.
So if we go back to court and then we agree on like overnight stays, am I able to put in like that clause where if he doesn't pick up the child, then obviously I go to work and then I need to sort out babysitter or like urgent thing, and he's liable to pay those fees, or is there not something that the court would approve?
No, not again. No, we can't force him to have contact. So if he's being inconsistent and he's causing you additional cost because you've got to get a childminder in to help you, there isn't too much we can do about that, sadly. And that's really rubbish, isn't it? Because that's just showing him to be such a bad co-parent. And I feel sorry for you that you have to deal with that on top of everything else. But unfortunately, the family court can't get involved in that. It's such a shame.
Yeah. Well, thank you very much.
All right. Pleasure. Thanks, Nancy. Take care. Bye.
I'm in a bit of a difficult situation. My oldest daughter, her dad currently is no contact with me, however, uses a third party to have contact with our daughter.
Right.
However, the issue I've got is he keeps threatening to take me to court for full custody of her. However, we've been under social services and they've deemed me to be like able enough to take care of her, and he's been deemed unsafe to be around as he is violent.
Yes.
However, I feel like in a difficult position because I'm scared that one day he is going to come and take my daughter, and I've already been told the police can't do anything about it because he technically still has parental responsibility, yet he hasn't seen her in over 7 months now.
Right. And are there any court orders in place at the moment?
No, I have got a solicitor, and when I have spoken to her, she has just basically just advised that we don't take any action until he does.
Okay, yeah, but if you've got a genuine fear, and again, I don't know, you need to go back and tell your solicitor the conversation that you and I are about to have. But if you have a genuine fear that he may snatch her, take her away, you can apply for what's called a prohibited steps order. And at least that just, set some sort of control around the situation. So it means that he cannot come and just remove her from your care without either agreement from you or an order from the court. So, and I think, because if you're worried that he might do it, there's every chance you believe he's going to do it. So he might do it. Do you know what I mean? So you need to speak to your solicitor about getting a prohibited steps order. Now, it might be that, and again, I don't know, Emma, but it might be that you're in receipt of legal aid and she can't get you the legal aid certificate for that because she has to prove to the Legal Services Commission that there's a genuine risk. So then you might think, well, okay, I'll do it privately. And I'll just get the prohibited steps order myself.
Mm-hmm.
Okay, so it's just an option for you, but it's the prohibited steps order, and you're just asking the court for an order that actually he's not allowed to remove the child from your care, and you can apply for that yourself if your solicitor can't do that for you on a C100 form. All right?
Okay, thank you.
Brilliant. Thanks, Emma. Bye.